A lot of clients will ask me, what do I need to do to avoid probate? And certainly the best tool that we have for probate avoidance is something called a living trust. It's a very common estate planning tool. And most of the time we would be talking about something called a revocable living trust, which means that you can make changes to it as you want, and that for all intents and purposes, the trust is considered your money and property because you're establishing the trust and you're acting as your own trustee. So what trusts do is, at least originally a trust, the idea was that you sort of separate the ownership of an asset and the management of an asset. And if you're setting up a trust, let's say for your grandchildren who are minor kids, that's how it's going to be. Your grandchildren will be the owner of the assets, and a responsible adult will be the trustee and will be in charge of those assets for the benefit of your grandchild. But if it's your trust we're talking about, and here we're talking about revocable living trusts, you are going to establish a trust with your own money and property, and you're going to be the trustee. Or a lot of times it'll be a husband and wife, so that Mr. and Mrs. Jones will establish the Jones Trust, and Mr. and Mrs. Jones will be the trustees. So what you're doing in that example is taking your money and property and just sort of converting it to a new legal form where you're still entirely in charge of those assets and the management of those assets. Why are you doing this? Well, because when you pass away, the trust continues to give authority to your child or whoever it is that you want to manage your affairs when you're gone, so that that person can transfer your money and property to the people that you specify without having to go through this court process called probate. Probate is the same idea, where your money and property goes to the people that you've specified in your will. The difference is that in order to get there, you have to go through this court process. It's going to take a long time, cost a lot of money, because it's driven by attorneys and you're in the court system. So the basic idea is that you can have a will that has a set of instructions about who gets what when you pass away. If you do a trust, it will have the exact same instructions. You can put exactly what you're going to put in your will into your trust, who gets what. The difference is, how do you get it there? If you're using a trust, your trustee is authorized to just carry out those instructions immediately at death. Your trustee is not going to have to hire an attorney to go through this whole court process. It's a good idea to have a lawyer involved, but you're not in the court system. The trust itself gives legal authority to your trustee to carry out your instructions. If you've got a will, it doesn't work like that. You're not going to be, your representative is not going to be able to just carry out your instructions immediately when you pass away like they'll be able to do with the trust.